Hello, hi, my name is Elizabeth Billies, and I am a divorce attorney in suburban Philadelphia. Talking Parents app has asked me to be here today to provide you my 7 tips for creating a custody agreement. Before I give you those tips, I wanted to tell you a little bit about myself. I have been practicing family law exclusively for the last 11 years in the Philadelphia area. And during that time, I have represented a few, okay, honestly, more than a few people in their divorces and in their custody matters. And during that time, I've seen a lot of different scenarios for custody, but I have developed 7 tips that I think are going to help you to create your custody agreement. So before we get into those tips, let's first talk about what is a custody agreement. What are we talking about when we say custody agreement? So it is a written document, usually made in order of court, that says where your children are going to be living. It also generally defines vacation time, holiday time. It also can discuss legal custody decisions, who has the right to make those. Generally, both parents do, but that can be defined in a custody agreement as well. Um, but most importantly, we see the fights over where the children are physically going to be. So that's what we're going to really be talking about today. You may also hear the language parenting plan. Sometimes parenting plans, what I've seen, have been documents that go beyond discussing physical custody, discussing holidays. They go more to parenting philosophies and how are we going to deal with discipline and how are we going to deal with electronics, those kinds of things. Sometimes parenting plans can become a custody agreement and are made in order of court. Sometimes those parenting plans are just more used to help the parents stay on the same page with regards to actually parenting their kids, and they don't actually become a custody order. So just to kind of clarify that terminology to you, today we're going to be talking about custody agreements that are ultimately made custody orders by a judge that are enforceable in court. So without further ado, let's get into the tips. So tip number 1, and I will recap at the end, but tip number 1 is be realistic about your lifestyle and your work schedule. Now, anything less than 100% is not enough time with your children. I get that. But when parties separate and divorce, obviously having your children 100% of the time is just simply not possible. So we need to be realistic about what actually is going to work for you and your family. And when I say your family, that does still involve your ex, because regardless of the fact that you are married, you are still a family and you still have to make decisions together because you have children. So, for example, if you travel for work, if you work a third shift, you need to take that into consideration when you're coming up with your custody agreement. Arguing for a schedule that you are incapable of doing, given your work schedule, is really just a waste of time. And it's only the court's going to look at you and say, why are you asking for this? You're not even there. You're not physically able to do it. So be realistic about what you actually can do given your day-to-day schedule. In addition, also think about where you live, where your ex lives, and where your children's school is. If you live an hour away from where your children go to school, and them staying at your house during the school week is going to require them to get up at 3 o'clock in the morning, that's not going to be a good schedule for your children. And so you need to be realistic. Again, I'm sure you would love to have your children spend a weeknight with you, but that's just not going to be workable for you or for them. And remember, we're always thinking about what's in the best interest of these children. So think about that. Is this in the best interest of my children? The answer is probably no. So step number 1 is, okay, let me think about, what do I do in a typical day from morning to night? Where am I? Where are my kids? How long does it take to get to all those places? And start with your custody agreement, start thinking about your custody agreement accordingly. So that's tip number 1. Tip number 2 is be prepared to not get everything that you want. Just like a Christmas wish list, uh, you could ask for everything, for Santa to bring you everything, but you're unlikely to get all of the items on your wish list. A custody agreement can often be like that as well, because for a couple reasons. One, again, you may be asking for your kids 100% of the time. Well, that's probably not going to happen. The other thing is that you also have to consider what the other party wants, and perhaps what you want and what they want may be in conflict. So you're going to win some, they're likely to going to win some, and that's how we come up with an agreement. It's usually not 100% of what one party wants. So how do you deal with this? My suggestion is make two lists. First one, what are your non-negotiables? What are the things that you need to have in your custody agreement? What are your priorities? For example, is Thanksgiving just the be all and end all holiday for you? Could you care less about Memorial Day? Could you care less about 4th of July? If that's the case, then that's on your list, on your first list. That's your non-negotiable. And so make a list where those things are on list number one. List number two is if I got it, it'd be great, but I can work on with that. So when you know what your priorities are, you can go into your negotiations about your custody agreement accordingly. So you stay focused on what's on list number one, and then you're not so focused on what's on list number two. If you have an attorney, make sure that you also give them a copy of this list. If you're going to litigation, if you're doing some kind of formal discussion, if you're going into mediation, which a lot of people use, which I think is a wonderful tool to resolve custody cases, bring those lists to the mediation so that you have them there, and so that these are the things I don't want to forget to have in my agreement. These are my things that I just want to be in there, because you don't want to do this more than once. It's expensive. It's exhausting. Let's just do this the first time. And you can make sure that you can do this, only once, when you have that list and know what you need. But also be prepared to give some stuff away. So if you know that your spouse's holiday, yours is Thanksgiving and theirs is Halloween, be prepared to give that away, because in more likely, if you're willing to recognize that's their big thing, that's on their list number one, they're more likely to give you what's on your list number one. So recognizing what are the priorities of both of you, and being respectful of that is going to help you in creating a custody agreement that you both can live with, and is more likely that you're going to actually come up with an agreement. Because if you fight over every little thing, you're just not going to get anywhere. I've been in those kind of negotiations where anytime the other spouse said something, my client just said no. And it was, I would say to him, a particular case I'm thinking of, what's the difference between a 5 o'clock drop off versus a 5:30 drop off? And there really isn't much, but it was just because she wanted it. And so going into the custody negotiations and crafting a custody agreement with that attitude, when you're fighting over things that honestly you don't really care about, that is a waste of your time, and you're unlikely to come to an agreement. So make your list of your priorities, be willing to throw away the rest. That's step number two. Step number three, take family holiday traditions and family vacations into consideration. So what do I mean by this? Is Thanksgiving, again, we'll go back to my Thanksgiving example. Is Thanksgiving the end all and be all for your family? Is that where your family visits from other places, from out of state, you get together, you do a whole big thing? Or is it an Easter egg hunt at your aunt's house? Is it a Passover? Is it 4th of July? Whatever that is for both you and your spouse, take that into consideration. And that's for two reasons, honestly. And remember, we're thinking about the kids here. We're worried about what is in the best interest of these children. So is it in their best interest to not get to participate in a family tradition where they get to see their cousins that they never get to see the rest of the year? They get to look for those Easter eggs or shoot off fireworks on the beach, whatever that is. That's a memory that they're going to have for the rest of their lives. And so why would you want to prevent them from having that? Why wouldn't that be in their best interest to have those memories and to have that time? I just don't see the reason for that. And so, that would be, you need to take that into consideration. There's ways that you can work with it. Well, you may be saying, okay, well, Liz, but I want to see them on Thanksgiving too. So, but there's things that you can do to work that out. So if Thanksgiving dinner is the big meal for your ex's family, and people come in from out of state or out of town that you don't regularly get to see, okay, well then that's, maybe his or her time every year. But you always get Black Friday, and you can create a new tradition with that. You've got brunch, maybe you go shopping, you go to the movies, whatever that is. You can create your own tradition. And again, when you are recognizing your former spouse's tradition, they're more likely to recognize yours as well. So, and again, at the end of the day, this is for the kids. This is what is in their best interest. And I think getting to experience those family memories is in their best interest. So that would be for the holiday piece. Vacations are similar. So like I said, I'm in the Philadelphia area. People go to the Jersey Shore pretty regularly. And I have a lot of cases where families go the same week every year. The whole family gets together. They rent a big beach house. They spend time on the beach. They play games, they have big barbecues, and that's their time together. And so if you have a standing vacation with your family, you can put that in your custody agreement. Most of my agreements allow for a vacation time. I'll just say 1 week or 2 weeks each summer or each year, depending on what the family wants. But you can put in a specific week, you can put in a specific month. Again, this custody agreement only works if it works for you. I always tell my clients, whatever works for you and your family works for me. I don't live your life. I don't know what you guys do for holidays unless you tell me. So my goal as an attorney, and I think most family law lawyers too, is to get a custody agreement that is workable. Because if it's not workable, you're just going to want to modify it. So part of it being workable is taking into consideration holidays, vacations, these special times. Another thing, and I like to have this as a provision in any agreement because it's something that does come up. And I think a lot of people kind of forget. And so it's like it's like tip 3A, let's say, is talking about family special events. So funerals, weddings, confirmations, graduations, first communion, bar and bat mitzvahs, whatever, any religious mile markers in someone's life that would apply to your family. Also consider those. I have a general clause I use for those, but I would suggest considering those. I don't think people think about them. They're so worried about getting, the big holidays down and the physical custody kind of stuff down, the regular physical custody schedule. They're so worried about that they kind of forget, like, oh yeah, what happens when cousin Joe's wedding is not on my weekend? How do we work that out? So consider that kind of stuff in advance, because that's another family tradition and a family event that you probably don't want your kids to miss. And again, they probably don't want to miss it too. So always think about what is, don't think about what's good for your ex. Think about what's good for them. It might be the same thing, and that's okay, but we're focused on the kids here. Tip number 4, again, consider your child's needs and their preferences. So I get asked, like the number one question I get asked is there an age where my kids get to decide where they want to live? Now, I don't know the laws in every state, but in Pennsylvania, that there is not such an age. There's no magic age that the child, they can go at age 14. That's usually the one that I hear, that people get to say, poof, I get to decide now, and I'm going to live with my mom, and I never have to see my dad again because that's what I want. That's just, I don't think most states have that. And I know in my state, they certainly don't, but obviously check with an attorney in your area if this is a question that you have. But the courts generally will consider a child's preference and will consider it the older they are. So they're not going to consider a 4-year-old's preference necessarily, but they are going to consider a 15-year-old's preference, as long as it's, quote, I say, well-reasoned. So I always give the example, if the 15-year-old wants to live with dad because they get to stay up till 2 a.m. and eat chocolate for breakfast, that's not really a well-reasoned preference. But if a kid wants to stay at, let's say at mom's, because mom lives closer to school, she's really organized, she always gets me to school on time, dad is a little overwhelmed. I'm always late. He forgets to pack my lunch. I'd really prefer to live with mom. Those are well-reasoned preferences. And I think a court will take those into consideration. And I think that the parties should take those into consideration too. We ask so much of kids in divorce cases. We really do. We ask them to accept, new people in their lives, new significant others, new siblings. We ask them to pack up their whole lives every other weekend and go to somebody else's house. We ask them to travel across the country to spend time with the parent in somewhere else in another state. And we should be thinking also too about what is the best for them. And so please consider that when you're making your custody agreement, what's going to work best for them. Again, going back to my first example of having to get up at 3 a.m., is that really in your kid's best interest? Is that really their preference? I would say probably not, knowing most teenagers. And so think about that. Another part of this is if your child has special needs. So if you've got a child who has special needs, who has difficulties with transitions, difficulties with new people, difficulties communicating in some ways, consider those special needs as well when coming up with your custody agreement. We always want to consider those. If your child has issues with transitions, maybe flip-flopping every other day where they are spending the night is not really going to be in their best interest. If they have services that they need to have access to in terms of a therapist or someone that comes to the home, can those services be accommodated at one parent's house or both parents' house? If it's only at one parent's house, then we need to probably craft an agreement where those services can still be rendered to the child, but they're because that's what they need. And again, we're thinking about what the child needs. If they can't work at the other parent, we're going to have to come up with a custody agreement that considers that. So always be thinking, it's like always bring it back to what's in the best interest of your kids. And it is considering them as individuals. And also, if you've got more than one child, what works for one child may not work for the other, though I generally like to have kids on the same schedule. And I think that the court system does too. And I think the parties, you as parents, probably do as well. But that may not always work, particularly if there's a big age gap. So you want to consider those kinds of things when coming up with your agreement. I think so many times we worry about the parents and it's the adults in the room having the conversation, and we're not like, let's play this out here. Let's play out this agreement. Is this really going to work for my kid? What am I asking my kid to do in this agreement? Is that really fair? And so I just ask you again, another tip for coming up with an agreement is to consider those things. The next one is develop a communication plan with your co-parent. So Talking Parents app is a wonderful communication plan. I recommend it to my clients. But having a plan of how you guys are going to pass information back and forth, pass back sports schedules and report cards and school notifications, whatever that. Technology is great. And so it's so easy to be able to do this now. I remember when I first started, we were relying on papers and book bags, and now parents can just go on a portal and get their kids report cards and know if they were, they turned in their assignment today. I mean, it's a lot easier now. It really is. It's really helped with, especially with parents that don't talk to each other. It's really made it a lot easier. But make sure that you come up with a plan, because you're still going to have to talk to each other. Even if you wish you would never ever speak to this person ever again. And there's those kind of divorce cases out there that I might be speaking, you might be nodding your head and saying, yes, Liz, that's mine. And I get that. But you have kids. And so you're going to need to talk to one another. And so developing a plan that's going to actually work for you is, you need to do that. And you can actually put that in your custody agreement. So I recommend to people, I put it in all the time, is that we are going to use Talking Parents app to facilitate communication. We're going to upload documents. We're going to make sure that we regularly check the app. and we respond to each other through the app only, and only use text message for emergencies or, logistical changes where there's only, you need to make a decision really quickly. So those are the kind of things that you also want to consider. I think a lot of people don't consider that till after. And whatever that communication plan is, use it. Um, Make sure you're using it, because I have so many clients who come to me and say, talk about miscommunication and someone was late and then the baseball equipment wasn't there. It was like, well, did you talk to each other? Well, no. You got to talk to each other. I'm sorry to say, maybe it's disappointing to hear, but it's going to have to happen. And so I think using co-parenting apps like Talk Parenting apps, Talking Parents app is a great way to do that without having to, get on the phone, which I know people really don't like to do. You don't have to talk in person. You can use the app. You can communicate what you need to communicate. We're all on the same page. We know where everybody has to be. We know what the children need, and we're following that plan. And I think also having a plan prevents you from having to use lawyers to facilitate that communication. And trust me, I gotta be honest, most lawyers don't want to have those conversations for you. It's also really expensive. So come up with a communication plan, save yourself some money. Definitely need to have that in your agreement. Next one, number 6, is plan for worst case scenario. So what do I mean by that? I have a lot of people who they get along really well, and that's great. I love that. I love when I see people who can co-parent together wonderfully after a divorce or a separation. I think that's warms my heart. You think, divorce lawyers would maybe not want to hear that, but it's the opposite. I love seeing parents work together for the benefit of their children after a divorce or separation. So a lot of times in those cases, I have the parties who have a very vague custody agreement. They'll just say, physical custody as agreed, holidays as agreed. They don't have specific dates and times in their agreement because they think, oh, we get along so well. We don't need that. Well, I'm here to tell you that you probably do. And you may be saying, but Liz, we get along great. Again, we don't need that. Why do you're making more work. You're making this more difficult, more negotiation. It's going to make it worse. You're going to make us, not have a great relationship anymore. This is why you need to have a specific custody agreement, and you need to plan for worst case scenario, because things change. You meet somebody, now have significant others. People move to different parts of the city, they have different parts of the county, different states. Someone's job changes, a kid's relationship with one parent or the other changes, and then the custody that worked before now no longer works because the child doesn't want to see that parent as much, or the child is now involved in sports, and so that results in a change. And I see when people have a very vague agreement and those kind of big changes happen in the lives of the children and the parents, that vague agreement's not working anymore. And then what do? Because you don't have anything in writing to tell you what to do. And so you say, okay, well, I'll just file, to modify my agreement with the court. And you can certainly do that. But the court system is not so quick. So if you have something where you're like, oh my gosh, we're really in a tough spot and we need to have this modification, ASAP, well, you're not going to get it. And so particularly if you don't have things spelled out for like holidays and you are in a fight over who has the child for Christmas Eve, and you come to your lawyer on December 23rd and say, help me with this, we need to have this resolved. A court system is not going to be able to help you in a day. So having that set out in a custody agreement particularly when you guys are getting along great and being able to come up with that amicably, helps you. And so if there's something does happen down the line where you do not get along anymore, you've got something in writing telling you what to do. I tell clients this all the time. Your custody agreement is your default. You can always modify for something different. If you want to change the custody, the transfer time on 4th of July from 9 to 10 p.m., you can do that as long as you guys agree. The court will not care. But in the event that you cannot agree on a specific provision of your agreement, a specific change, then the court and the court's going to look at, well, what does the agreement say? What does the order say? What is this telling me that you are supposed to be doing, and whether and did you do that? So that's why having a specific agreement is only going to help you. Again, you can always deviate from it if it's by agreement, but having something just kind of as your baseline is really, really helpful. And I will also say, this is kind of like a tip 6A, I'd say, if you start to deviate significantly from your custody agreement, this happens to me all the time. A client comes to me, they do a custody agreement, 5 years go by, they come see me because it's not working for whatever reason. Maybe I did the agreement before, probably didn't. And they say to me, well, oh yeah, we haven't been doing that for years. Well, that's the problem, is now the court's going to look at what's on the paper. They're not going to, you can tell them, well, we've been doing the same thing for 3 years, but what if the other side doesn't agree? So having what's in writing that is relatively what you're doing is really important. So if you are going to make significant modifications over the years, just update that in writing. That's really important because, again, we don't want there to be confusion when there's a discord. Because the court system is so slow, we don't want that. So you want to make sure that your agreement, it's a living, breathing document, and you want to make sure it's actually reflective of what you're doing. Okay, last one, number 7. So it's kind of the opposite of 6, and you're like, well, Liz, this is weird because you're telling me this in number 6, but now number 7 is a little different. So in number 7, I'm saying, understand that your agreement cannot cover everything. So while you want your agreement to be as specific as it can be and to cover as many things as you can think of, we all know life happens. I mean, who thought that COVID-19 was going to happen? Nobody. How many people's custody agreements considered what to do in a pandemic? I can promise you, probably none. So we had to think on the fly. We had to adjust. Families had to adjust. Lawyers had to adjust. We all had to adjust as a society. And so understand that your agreement, it can't cover everything. It can't cover every single what if, because we can't think of all the what ifs that could happen. So being flexible with your co-parent and understanding that we all have to give each other grace at times and give each other ability to modify is really important, because the shoe's always going to be on the other foot. You may be asking for a change because all of a sudden, Aunt Sally is here from California and you didn't know she was going to be here, and it's a surprise visit and it's not your custodial weekend. And you don't have a clause in your agreement about when Aunt Sally comes to visit, and you want to switch weekends. And so let's hope your co-parent says, okay. Well, what happens if, 3 months from now, your co-parent has a family barbecue or a family birthday on your weekend and asks you to switch? Think about what your co-parent did for you, and be flexible and work together. Again, it's for your kid's best interest. It's their best interest probably to see Aunt Sally, and it's probably in their best interest to go to that family birthday barbecue. So you need to be able to work together because life happens. And so to hold somebody to the letter of the agreement without considering that we need to be flexible with one another is just not realistic. It's only going to lead to acrimony, and it's only actually ultimately going to burn you, because I promise you, there will be a time where you need a modification and the other person will remember that you didn't give them one. So do consider that. So again, just to recap, I want to recap the 7 tips for creating a custody agreement. So tip number 1 is be realistic about your lifestyle and your work schedule. Number 2 is be prepared to not get everything that you want in your custody agreement. Number 3 is to take family holiday traditions and vacations into consideration when creating your custody agreement. Number 4 is consider your child's needs and preferences. Number 5 is develop a communication plan to speak to your co-parent about custodial issues. Number 6 is plan for worst case scenario, whether you like it or not. And number 7 is understand that your custody agreement cannot cover everything, and act accordingly. So I really hope that these tips were helpful to you. If you'd like more information about myself and my work, you can see me on social media. I'm at The Divorce Lawyer Life on Instagram, on Twitter, on Facebook. Also can come visit me at my blog at thedivorcelawyerlife.com. I'd love to have you. I love providing information to parties to help them through this scary and transitional time for them and their children. And I really hope that these tips can help you either create a new custody agreement or modify your old one. And with everyone with COVID-19, stay safe, wash your hands. And again, if you need anything, please come find me on the internet. Thanks.